Alright, we're back, everybody. This is going to be video 2 for Reform Utah Family Law. This is January 28th, 2016. Far past time to get some updates for you. We've already done one initial update today, just kind of give you a status update and ask everybody to get involved, purchase some materials from us, start working with us. Let's work towards the end goal of getting some laws changed here. So let's jump right into the second video, which is more personal for me. It's about my case. I've shared some of my case in the past, and I kind of want to do that today as well, since my case was up before the Utah Supreme Court originally. It was pushed back to the Court of Appeals, and which was fine. And I filed that last year, initially early in the year. Final arguments, responses from me came in June, and I just now received a decision from the Utah Court of Appeals. So I'd like to share that with you. So, let me grab some materials here, and we'll kind of share what we got. So I'm not going to give too many specifics on my case number or anything like that. It's personal, I guess, information. But anyway, this was my original, what you would call appellate's opening brief for appeal. Now, I spent a long time preparing this. This had, with exhibits and everything else, probably over 100 pages. Got that filed last year towards the beginning of the year to preserve my appeal rights on my case for a number of issues that I have appealed, well, obviously all the way up to the state Supreme Court, and then it was turned over to the Court of Appeals. So in response to that, I had what's called the brief of appellee, and this would come directly from the guardian ad litem, which is the part of the case that I appealed. And so let me kind of show you that real quick. You have a number of exhibits here. Anyway, he had a very lengthy response, and there's quite a few exhibits in there. And then finally, I had my reply to his brief. So that was called the appellate's reply to appellee's brief. And let me hold that up for you. I know a lot of you may not be familiar with this process, so I'd like to share a little bit of that with you so you at least get some familiarity with this stuff. Now, these would be the documents. The state of Utah, in my opinion, and I'm going to give you a little bit of opinion basis here. What they do have a lot of very specific filing requirements. Now, and when I say that, what I mean is this. So, backtracking here a little bit, I filed my entire appeal. You've seen those documents I just showed you. Every one of those documents has to follow a very specific process, has to be formatted specifically, and even right down to the colors of the front pages, as you can see. If you do not get those correct, you can, in essence, have your appeal thrown out. So you want to spend some time familiarizing yourself with those requirements if you ever find yourself in the position like I did of appealing part of your case, one or more parts of your case, because they will find every reason that they can within the 3rd District Court system and the appellate court and the Supreme Court, even here in the state of Utah, to throw your case out when it comes to family law, in my opinion. So, okay, I'm back. Apologize for that. I had a separate phone ring here I had to take care of at home. Apologize for that. Anyway, let's get back on track. So, uh, that was my personal opinion there. I believe I have a very accurate and reasonable opinion to base that I've based my facts on. As far as the state goes, it's one step they have to frustrate and stop pro se litigants from filing valid appeals as part of the appeal process, in my opinion. So, anyway, that's one little part of the appeal process you need to be careful about when you file. Make sure you file everything correctly within the right time, and really very specifically according to their document requirements as far as layout and everything. So moving on from that, let's get back on track here, and let's talk about the appeal decision that came in, and a little bit about my case so you have an understanding. So I did receive a decision finally on my appeal. Now, initially it was filed very early on in the year. My final paperwork was turned in June for my final reply to the opposing side, and so I received a decision January 5th, 2016 in my case from the Court of Appeals. Now, in a nutshell, let me kind of just show you here. It gives you some basic idea. This thing's, anyway, it's not very long. It's a really short and non-inclusive response, and it's quite frustrating, and frankly that's the way they intended it, and let me explain that to you. So I received this order of summary affirmance, which in layman's terms that means they've upheld and affirmed the original decision in the 3rd District Court regarding my complaints and the things that I appealed as far as the guardian ad litem being involved in my case go. Now, there was a whole slew of things. I'm not going to go into all that right now, but a couple of the biggest things that stuck out in this response for me was the first one was the fact that this guardian ad litem, he's now retired, and halfway through this process, he began having another attorney represent him in his responses to my appeal. Now, they can technically do that, and it's not an issue, with a couple of catches. First one being they need to file a motion of appearance for the new counsel, substitution of counsel, and they also need to withdraw from the case. Well, midway through this process, in his response, which was prepared by this other attorney, he never filed any of these documents that are absolutely required, and especially when you're at the Court of Appeals or the state Supreme Court level, he never filed any of these documents. My argument in my final reply brief was that, hey, look, let's set all of these issues aside for a moment and look at the fact that he has failed to follow proper court procedure and file the necessary documents to withdraw from the case, as well as have a new substitution of counsel. I cited specific case law, and here in Utah, I cited specific cases that came before the state Supreme Court, and they sided with the petitioner when they filed motions in regard to this issue. And one of my issues that I filed in my final reply brief was that, based on the fact that he hadn't filed these necessary documents to make a substitution of counsel and to withdraw from the case, he was required under law to remain on the case until approved by the judge in writing to be dismissed from the case. And further, his entire reply brief, which was also 4 days late, I might add, past his filing deadline, should be thrown out because it was prepared and filed by this other attorney that had taken over the case for him, the substitution of counsel. Now, state law is absolutely fundamentally clear on this, and I cited some very specific cases where the entire argument, frankly, was thrown out from the one side in the case, whichever side it may be, because they had not filed to withdraw from the case and they had not filed a substitution of counsel. This issue was not even addressed remotely in this very brief and short, it's about 2-page long response from the Court of Appeals here in Utah. So what they did is they sidestepped and skirted around one of the most fundamental issues in the midst of this appeal, and that was that his entire briefing argument should have been thrown out. And they clearly did that to frustrate me, to frustrate the process, frankly. And not only did they not throw out his argument and basically rule in my favor based on those facts alone, because once his entire argument is thrown out based on the fact that he hadn't followed correct procedure, and mind you, this is not somebody who just started practicing law. This guy was old enough to retire. He's been practicing law 30 plus years. He knows the correct process. He knows the filing deadlines. He knows the documents he needs to file for a substitution of counsel. And frankly, the Court of Appeals here turned their noses up at my argument and basically acted like it didn't exist, and it really pisses me off. What it shows is there's an absolute fundamental and clear bias on the part of the Court of Appeals here to frustrate pro se litigants, to keep them from pursuing justice in their cases when they have valid arguments and complaints. And not only did they reaffirm the decision to award this clown nearly $12,000 in my case for 3 hearing appearances, but they also awarded him attorney's fees for this woman attorney that took over the case for him without filing proper notices and without filing anything she needed to file to correctly do that. And not only that, again, we come back to the fact that his response was 4 days, filed 4 days late after the deadline. What does that tell you? Well, it tells me a lot of things. It tells me not only that, frankly, these judges here in Utah, they all pat each other on the back and make sure that one's decision is upheld, whether it is constitutionally valid or not. But they are going to protect this broken system with the CPS workers, if that's who you have involved in your case, the guardian ad litems, and anybody else involved on behalf of the courts. They are going to protect them at all costs, and it doesn't matter what you have to show as evidence. It doesn't matter what the correct legal procedure is or precedent. It doesn't matter what cases you quote, what statutes you quote. Frankly, they don't give a shit. And they're going to continue to rule against pro se litigants. They're going to continue to interrupt parental rights without any justification to do so. And frankly, I know what the problem is here in Utah. A number of us know what the problem is. It isn't about recreating new laws in Utah in all the situations. We have a lot of good laws on the books. And frankly, what it is it's not the legislators, it's not the laws, it is the judiciary branch of the government here in Utah, the judges, point blank. They do whatever the hell they want to do. Let me say that again for you. Don't go in front of a judge and expect justice in family court in Utah. They will do whatever the hell they want to do. I was naive. I was a fool when I started this. I believed that you could go in front of a judge, have your rights upheld as a parent, have your rights protected. I thought, I've got a parent on the opposing side who is playing all of the textbook parental alienation tactics. She's doing everything she can to stop me from being part of my child's life. She's falsely accusing me of things that were, frankly, they were laughable. I'm going to be fine. You know why? Because I do the right things. I don't have a criminal record. Hell, I don't even have a parking ticket on my record. Courts are going to protect me. I'm here to tell you they don't. That is the biggest bunch of bullshit you're going to see anywhere. I don't even know how to describe that other than that. It's not reality. Reality is they're not about protecting your rights. Let me say that again. The courts are not about protecting your rights as a parent. They're about trumping your rights. They're about doing what they want to do, and they're about controlling parents and their rights. Now, the state constitution, I've mentioned this before in other videos, the state as well as the United States Constitution make it absolutely fundamentally clear that parental rights trump the state and federal rights to intervene or supersede parental rights unless there is a direct threat to the child's safety. That's laughable. That is absolutely laughable because these courts here in Utah and across the nation are doing whatever the hell they want to do. They're stepping into cases where people, many of them like me, have never broken the law. They're there to try and protect their rights to be involved with their child. They're not going to protect you. You need to protect yourself. And we need to get involved. Like I said in the last video, there's a lot of organizations out there on Facebook. There's a lot of organizations, even here in Utah, that are national organizations that claim they're working to change Utah law for families and change processes for families here and in other states. And frankly, they've got a set of objectives and a mission that is very specific, in many cases right down to the individuals working that local level, where they are trying to put themselves personally in a better position, and they don't care about the betterment for all parents in that situation. I know this firsthand. I've been part of a number of national organizations that they do work on behalf of parental rights. I've been on the boards, and a number of them are good. Frankly, there's a number of them that I know absolutely fundamentally that they are corrupt at their very core, the same way that these courts and these governments are, and they're after personal missions. And we'll leave it at that. But what I'm trying to tell everybody in this video is that you need to protect yourself. You need to protect your own rights. You need to be diligent and continue to step up and try to enforce your own rights. Frankly, there's nobody else out there that's really going to do it for you. And with the organization that I started, the reason I started it was because of the corruption I saw in some of these other organizations. And I wanted to have a tool, a self-help tool for everybody out there. I'm going to tell you right off the bat, we're not here to win your battle for you or take your battle on and claim that we're going to get you everything that you want. Every case is different. Some people are guilty of parental neglect and abuse, and rightfully so have their rights limited. Many, if not most, in my experience, either have their rights far too restricted or stepped on, or the courts should have never gotten involved and superseded their rights as parents in the first place. That's been my experience. So what we're going to do as Reform Utah Family Law for you is simply be a resource, a teammate. We don't claim to have all the answers. We don't claim to have a specific process that's got to be followed to the T to get this job done, to change things. What we do have is a lot of angry parents, a lot of parents who have had their rights demolished, stripped. We have a lot of parents that have been embarrassed, depressed. They've had these courts trample on them, not just their parental rights, but talking humanitarian rights, where these courts come in and they basically dehumanize these parents that otherwise, frankly, are probably pretty good parents most of the time. And I've seen far too many cases personally that I've sat in on where I know that the stuff going on in the courts is bullshit. And I'm not going to mince words anymore. The more that these courts, try to resist the change and try to throw things at us, the more attention I'm going to bring to it. I'm tired of it. I'm really tired of these irresponsible, downright criminal judges doing the things they're doing to families in this country, and specifically in the state of Utah. And it's time for change. Anyway, I'm going to leave it at that for this video. I gave you some details on my case. There was a whole lot more that wasn't addressed in their response. And basically what I have now is a decision to make. I've already got myself lined up with a national group that I have signed on as a plaintiff for an upcoming filing on a federal lawsuit against the states. That's a class action lawsuit coming up. The filing, I believe, will happen in March. And other than that, on this decision that came in, I've got a decision to make. I can either appeal it at the state Supreme Court level, which frankly I have no faith that anything's going to be changed at this point, or I can look at filing a federal lawsuit with some injunctions against the state and the guardian ad litem. In my particular case, I have never committed a single crime. I have, the reason that I'm tied up in the courts is because I have gone and fought over and over and over to be part of my daughter's life. I was able to enforce my rights for about 8 of the 17 years she's been alive. So I was able to see her for about 8 years. And her mom took her away again a couple years ago without any type of legal justification or reasoning to do so. I got tied back up in the courts because I wanted to enforce my parental rights. I've been paying child support all these years. I've never committed crimes. I have custody of my other daughter who's lived with me since the day she was born. Her mom's well aware of that. She's happy with the living arrangements. We have a pretty good working relationship. But yet I somehow am not fit enough to see my oldest daughter, and the courts took it upon themselves to involve this retarded, moronic, and I've got a lot worse words, but anyway, this guardian ad litem, he was appointed to my case a couple of years ago. He attended about 3 hearings, filed a couple of pieces of paper, and was supposed to split the bill between me and the ex I was there in court fighting. And the bill supposedly is about $12,000 if you cut it in half. My half is he's tried to bill me for is $6,000. I refuse to pay it. I won't pay it. I'm not going to pay it. I will never pay somebody to kidnap or extort my child from me, ever. He's filed a lien on my home, which is fine because I'll just stay living here as long as it takes. He won't ever get paid. Not going to pay somebody to kidnap or extort my child from me. So, as you can tell, I'm pissed off with this latest response from the Court of Appeals. Doesn't mean I'm going to stop. You know, if we have to see this thing all the way through to the United States Supreme Court, then that's what we'll have to do. Anyway, get a hold of me. I'm available on R.U.F.L, Utah, to all the members. You can always get a hold of me, and you know how to reach out to me. I'm here to help as many people as I can, do what I can to offer resources or steer you in the right direction, and get involved, people. We need every one of you that are being wronged by these corrupt, narcissistic, and criminal courts and judges and family workers. We need every one of you to get involved to help fight this, change it, and ultimately hold these people accountable. In my opinion, not only should the family workers be put in jail for what they're doing, but these judges should go to jail too. So, I'm not going to stop bringing attention to this thing. You shouldn't either. Get involved. R.U.F.L Utah on Facebook. We have materials available. Contact me, and let's keep moving forward. Everybody out there, stay safe. Stay safe and fight the good fight. Be careful about the battles you pick. And remember, ultimately at the core of this, family is what's important and what's being destroyed. Family. So, till next time, hang in there, everybody.